Delivery of judgment item 21 to 25. WBC 470 of 2020 and connected.
Late President stands dismissed. Will sign current.
May I please your lordship? Lordship, I am sorry for mention the item number 18 to 15, lordship. It's a very old matter. Lordship, today, my senior has some difficulty, lordship. Kindly.
Item?
18 to 15, lordship.
18 to 15.
Yes, lordship. Only for the day, lordship.
No, it's 2015 matter.
Yes, lordship.
What's there?
Yes, lordship. Yes, lordship. Tuesday, lordship. Tuesday.
Tuesday we have fixed so many matters.
Okay, lordship, as per your. Lordship, there is an interim order. It may be continued, lordship.
I am not inclined to adjourn the matter. What's there?
Actually, lordship, the writ petition has been arisen out of the order.
You want a permission?
Yes, lordship, for adjournment, lordship. No, lordship, I want to adjourn the matter. Kindly echo.
You know, what is your grievance in the writ petition?
Lordship, yes, lordship, lordship.
You want a construction permission?
Yes, lordship.
Then what?
Lordship, the order has been arisen under section 88 under GMD Act 1985 by the to vacate or stop the construction made by me.
Yes.
Lordship.
You have not obtained instruction, permission.
No, lordship.
What's
I have
wrong?
obtained permission, lordship.
They will grant you permission. We'll set aside the order. Then where is GMDA, GMC?
Lordship, we have taken consent yesterday, lordship. Actually, today we have some difficulty, lordship.
So last chance, huh? On the prayer of 8 to 15.
Yes, lordship.
Hmm. Your name, please. Me, MS.
R. Kakoti.
On the prayer, MS R. Kakoti. Why it should be adjourned?
Lordship, actually, there are some connected matters. From all, we could not able to trace out all the files.
We are not concerned. That should be followed after this thing. No reason, I think.
Lordship, my seniors has also some
Have some
difficulty.
come with some semblance of reason. Anyway, on the prayer of MS M. Kakoti, learned counsel for the petitioner, list this matter. We list these matters after 2 weeks. List of it is made clear that no further adjournment shall be granted on the next date, as the matters are pending since 2015. Yes, after 2 weeks.
Interim may be continued, lordship.
Interim order passed earlier shall continue.
Maybe so lordship, my lord, item number 7, my lord.
Yes,
My 7, my lord, AU Chaudhary.
this is also 15.
My lord. My lord, out of station, my senior, my lord. So
So, what
consent
can we do?
consent the other side, my lord. Maybe, my lord, please, after 2 weeks, my lord, matter. Out of station, my lord.
Next week, on the
After-
prayer of
After 2 weeks, my lord.
next week, on the prayer of Mr.
Jad Hussain,
Jed Hussain,
my lord.
learned counsel for the petition, list this matter after a week. List of considering that the matter is pending since 2015, no further adjournment shall be granted
Obliged.
on the next date, huh?
May it please your lordship. Lordship, I beg to mention item number 16.
16.
But may this matter come after a week because we need to file our affidavit in reply in this against the affidavit in opposition filed by respondent number 4.
On the prayer of Mr. So-and-so. Your name, please?
MZ Rahman.
MZ,
Rahman.
Your
On
name
behalf
is
of
not there.
NSAICA, on behalf of NSAICA.
appearing on behalf of MS NSAIC and Council for Nutrition. Let this matter be listed after a week so as to enable him to file, enable the petitioner to file affidavit in reply. Yes.
Deeply obliged.
May it please the Lordship. Lordship, I beg to mention item number 20, Lordship.
Hmm.
Lordship, there is a prayer for adjournment, Lordship, with the consent of the other party, Lordship.
Hmm.
That if the matter may be listed after 1 week, Lordship.
You're for
I am for the petitioner, Lordship.
Mr.
B. Sharma on behalf of Dr. A. Sharma.
On the prayer, Mr. B. Sharma, learned counsel for the petitioner. List this matter after 2 weeks.
Oblige, Lordship.
May I please your lordship, with the consent of others, I beg to mention item number 17.
Hmm.
Mr. Senior Counsel, Mr. P.J. Soiga is out of space. Kindly matter may be adjourned for
On the prayer of Mr. So-and-so, learned counsel appearing on behalf of Mr. P.J. Seke, then senior counsel, who is reportedly indisposed. List this matter after 3 weeks.
oblige.
This is just one. Yes, sir.
My lord, may it please your lordship.
Hmm.
My lord, the petitioner was owning a garden, which is known as Balipara Tea Company Private Limited. Now, there was PF dues, so notice was given to him. Thereafter, my lord, a recovery certificate also was issued. Ultimately, what the amount could not be paid. Certain amount paid, but not fully the amount. Ultimately, the PF has auctioned the garden by way of notice, and ultimately they recovered about the amount, total amount of the garden was 5 crores 97 lakhs. That was the total amount of the garden. But the PF dues, which was due to the PF authorities, was 197,47,669. So what our case is that the 197,47,669, yes, you are entitled, you can recover it. Second, gratuity also you can recover it. But so far as the other claims are concerned, you are not entitled to recover. The PF authorities. Now, in notice, why we came to the court, a public notice was issued saying that there are other claims of respective parties.
Hmm.
We came to the court and we said that you are not entitled to recover the other claims. You are entitled only to recover PF and gratuity.
Yes.
Then the court has stayed. Now affidavit are being exchanged and they have filed an affidavit. Also they said, my lord, in their affidavit,
Yes.
kindly see our petition, my lord, first, read petition, my lord. Please see the read petition, my lord. Read page 27, my lord. 27. That is the notice, final notice, lordship got it, at page 27, on the top,
Yes.
final notice on the top, kindly see page 27,
Hmm.
dated 15/07/2019.
Yes.
And
28 is the recovery.
28
Yes.
is the recovery certificate.
Interest.
Can I read the 28, my lord? This is important. One, that is 1/10/2019. This is to certify a sum of rupees 1,97,47,669, which is due from Balipara Tea Estate against the area PF contribution, PF administrative cost so and so, plus 15% statutory interest on delayed deposit of PF contribution, damage charges on liquidation, Bakijai cases, DLI contribution, DLI so and 15% statutory interest on delayed deposit of so and so are in area. Now with reference to the provision of section 15B1 and 15B2 of so and so, you are requested to recover the aforesaid dues according to the provision of the said act. Now,
The consolidated amount inclusive of.
so this was the total amount inclusive of the interest. Right now, my lord, will kindly see, some payment we could be, we paid at page 30. But we could not pay the entire amount. So they took possession. If your lordship kindly look into the possession, page 32. Page 32, they have taken the possession. As we could not pay at page 32.
Yes.
These are inventory of attachment of movable immovable properties. So 34 is the Jimma. Kindly see 34, my lord. Appointment of new general manager of Balipara Tea Estate at page 34. And 37, we sought. Please see 37, my lord. Seeking details of auction. We came to know that there was an auction which was carried at page 37. After attachment, Jimma ended. Then 37, we came to know that it has been auctioned. Notice was issued for auction. Now 37, seeking details of auction, man. At page 37. This is 18th of December 2021 letter.
Yes.
18th of December, kindly see my subject. Sale of Balipara Tea Estate by so and so. Sometime in the month of October 2021, physical person subject tea estate was given to buyer under the direction of so and so. Sir, in this, kindly apprise as the following. How many parties participate in the bidding? What was the sale consideration terms? When we can get balance amount after adjustment of PF dues? Now, they did not reply, and at page 38, public notice was issued. It doesn't reply. At page 38, public notice was issued. This was put to challenge.
That, my lord, just I'm appraising your lordship, my lord, that public notice we have already.
No, no,
written,
let me
that
complete,
is
my
also
lord.
that-
No, no, I
according in
will-
the order sheet also.
no, no, I will,
That
let
is
me
reflected in
complete,
the
my
order
lord.
sheet.
How I came to the court, I have to tell, my lord. Then I will tell this has been withdrawn. See at page 38, my lord. In pursuance to the, at page 38.
Yes,
In
yes,
per-
I've seen.
Yes, per so and so, so and so. Now this was put to.
So you are challenging this.
The challenge, and there
If
was an
you-
interim order which was passed. Thereafter,
They withdrawn.
they have withdrawn. Now the
But then what
police.
remains?
Now I'll tell what remains. I file an affidavit. They file an affidavit, kindly see.
11.
Page,
Page, it starts from
84.
84, my lord.
84.
Yes. Lordship got it? 84?
Yes. Yes.
Yes. There
Additional,
are 12.
additional affidavit
Yes. Now para 14, kindly see.
filed by the respondent.
Yes. PF authority.
2, 3 and 4, my lord. 2, 3, 4 and 5.
See para 14, my lord. At page 90.
Yes.
That a deponent in compliance with the direction contained in the order dated 8/5/2024 passed by this honorable court in the present writ petition furnishing herein under the following information.
Yes.
We sought for free information, my lord.
Hmm.
Query number 1. Against the letter dated 18/12/2021, deponent stated a public auction held on 7/10/2021, two bidders, namely Umatara Tea Company, Vishal Automobile Tinsukia, partitioned the aforesaid public auction held on 7/10/2021 by offering their bid amount. Query number 2. Against the aforesaid letter dated 18/12/2021, Umatara Tea Company offered their bid amount of 5 crores 97 lakh. Vishal Automobile offered their bid amount of so and so. As the bid amount offered by Umatara Tea Company being found to be the first highest consequent upon which Balimara Tea Estate had to be sold at Umatara at their bid amount. Query number 3. This is very important. Against the letter dated 18/12/2021, deponent state after adjustment of all areas, PF dues and other statutory dues of Balimara Tea Estate from the auction sale proceeds of 5 crores 97, there was no balance amount which could be given to the previous management of Balipara Tea Estate. In fact, the sale proceed admittedly was not even sufficient to meet the entire area's liabilities, including workers, employees' dues and other statutory dues of earlier management of Balipara Tea Estate. In support of his deponent is enclosing a copy of letter dated so and so. Now, page 96 is the letter. Kindly see page 96. Statement of the account.
95 is the 95 is sitting on nothing.
95 is a letter. 96 is the statement. Kindly see, my lord. With reference to sale proceeds and due of Balipara Tea Estate, duties of so and so, recovery certificate 1 crore. So these are the mentioned monthly gratuity contribution, that is fine, my lord. 6 crores 0983. Now, if your lordship turn to page 97. 97, bonus due to be paid before Durga Puja. My lord, they are not the authorities that they can adjust with that amount. The bonus due to be paid for Durga Puja, workers due the claim on so and so. So when this was sold to Umatara, it was sold as it basis. So there is no question of they calculating all this bonus. They are not the authorities. This is our case. So my lord, whatever recovery they made under PF, absolutely fine. Gratuity, no problem, absolutely fine. What is a balance amount they have kept? That is not their payment. They have to return back to us because the garden has been sold at 5 crores 97. My case before this court is that you are entitled to recover. I could not pay you. You issued a recovery certificate. Thereafter, you made an auction. Where is the now we made a reply also, my lord. Kindly see the statement, my lord. See the statement. My lord, kindly see this. This is, we made a note. This is the amount claim under recovery certificate is 1 crore 97, my lord. Amount payable is 1 crore 63, my lord. And total recovered by the respondent is 3 crore 61.
This PF plus gratuity.
Pay plus the gratuity plus
PF.
the PF dues. Now this is through auction, 5 crore 97. So due is 2 crore 35.
Which we are entitled to refund.
So we are entitled to refund. They should refund back to us 2 crores 35. Where is the authority to retain this 2 crores 35? Adjust with some other amount, which they are not the authority to do it under the act. 2 crores 35 is with them. Kindly see, my lord, 1 crore 97. This is the PF recovery certificate. Amount payable as gratuity is 1 crore 163 82 0369. Total recoverable by the respondent authority is 361 29 708. Now, amount received through public auction is 5 crore 97. Amount refundable to petitioner is 2 crores 35. So this is our case. They should refund back to us.
No, they are saying that, in fact, they have paid, I mean, it's not also sufficient. This 5 crore, 97 is also not sufficient.
But they, my
Because
lord,
we added-
they have
Then is
added
it,
some.
sir, is it not a case of, I mean, civil, dispute?
No,
now?
no, there is no dispute in it.
There's a dispute.
No, I'll give a reply. Give me immediate, I'll give a reply.
Hmm.
There cannot be, why? There cannot be dispute only on the ground under the statute. They are the authorities under what? Under the statute. They are the authorities under it. My lord, dispute will come if they are the authorities to recover other dues. They are not the authorities to say that no, I'll keep this money because there is other third party claim amount. They are not entitled to it under the statute.
So according to you, just some of the payments, except this,
PF and gratuity.
PF and gratuity,
PFP and gratuity, the other amounts, they are not
not entitled under the
authority
statute.
to pay.
Correct, my lord. They are not under the statute, my lord.
Ah.
Statute, PF and gratuity, they are entitled. We are not disputing about it.
What is their statement? 97 or something like,
Page 96.
96.
96.
Yes. Okay. What has the payment?
Page 97 is
Yes.
the bonus due.
Yes.
See page 96,
Yes.
it comes around six
They-
amount. Forget about the next
No, no.
page.
They included some interest. We have given reply. Page C 28, my lord. 28 of the writ petition. C 28, my lord. C 28. They have to go by writ petition. They cannot come with a new affidavit. They will hit by the judgment of Mohinder Singh Gill. Kindly say 26, my lord. 28. Kindly say 28. This is the amount which is inclusive of interest where the recovery certificate was issued at page 28. See, my lord, page 28.
This was in 2019
Correct.
and this payment was in 2022.
How can do it? Your certificate, recovery certificate you have, they
That-
cannot go beyond that.
No, obviously the interest and everything will come.
No,
This
this,
will accumulate.
no, my lord, your accommodation, my lord, that is, my lord, 1 crore 97, 15%. They are saying something about 2021, 22. How can they do, how can they calculate something which is a part of what a notice given to us?
They are not entitled to
They are not,
impose an
no,
interest.
they can do what, my lord? They are entitled. They are entitled to
See,
give a
provided-
fresh notice to us.
Show us the provision that
Yes,
under the statute that they cannot
yes,
accept the principle.
yes. Principal statutory interest, but on the basis of a notice which they have issued. Not beyond that notice, they cannot issue. Notice.
I think that will be too harsh, sir. I don't know, subject to what the statute provides,
Yes.
but that will be too harsh. PF amount, you could not pay,
No, I could not.
and if there is a delay,
My lord, I am.
suppose there is a litigation and other
Yes.
thing. Bona fide, I mean, pendency. Otherwise, the interest, if they are entitled,
They are entitled. I am not saying
that,
that.
that will be on the day of the payment,
No, I
not
am
the
not-
day of the
Kindly
the
see.
cause of action.
My lord, see, when it was auction case, what is it? 21.
Yes.
Yes, my lord will kindly see. PF, my lord, see the statute under section,
Yes, which one?
section 15 kindly see, my lord. Amended 15, my lord. 15? Lordship got it? 15?
Yes, 15.
15 at page 241. 15B1. Kindly see down below 15B1. Where any amount, Lordship got it?
Just wait.
15B1 at page 241. Issue of certificate of recovery officer, which the certificate was issued. Where any amount is in area under section 15, the authorized officer may issue to a recovery officer a certificate under his signature specifying the amount of areas, and a recovery officer on receipt of such certificate shall proceed to recover the amount specified therein from the plantation, or as the case may be, the employer by one or more of the modes mentioned herein below. So they have attached and they have sold as it is basis. Now, my lord, will if you see at page 15B, to recover the amount specified therein, provided that the attachment sale of any more under sale shall first be effected against the properties of the plantation, and where such attachment and sale is insufficient for recovery of the whole of the amount of areas, recovery officer may take such proceeding against the property of the employer for recovery of the whole or any part of such areas. So they have to confine only to this certificate that has been mentioned. They cannot go beyond that. Now, my lord will kindly see from where they found this amount. We are on that. These 3 crores, which now, my lord, what they say, my lord will kindly see what they say in B at page 96, which was inadvertently not added to the, is an admitted position by them. Kindly see at page 96, they have admitted. B, at C, page 96. You cannot recover something which you have not, have not mentioned in notice. See at page 96, my lord. At B. See at B, my lord. Additional areas PF contribution. That is 10-9, 10-9-99 to 28-3-2019, which was inadvertently not added to the aforesaid recovery certificate due earlier. Earlier recovery at page 28, kindly see. Kindly see, my lord. Which was inadvertently not added. It is you have done mistake. You have not added. Now you are adding something which was not there in the recovery certificate. How can you do it? It is beyond 15B. It is beyond 15. 15B1. Gratuity also they have not mentioned, but they are entitled. Because now the PF recovers, they play the role of the authorities that they can recover it.
Let us read the 15 first.
So I'm sorry, my lord, 15.
15.
Yes. 15.
Hmm.
Recovery of
15B
money.
one is a mode of recovery.
15, 1,
15, 15.
15.
Let us see.
Yes, recovery of money.
Hmm.
Any amount due from the employee in relation to plantation to which any scheme or the insurance scheme applies in respect of any contribution payable under this act to the fund, or as the case may be to the insurance fund, damages recoverable under section 16, accumulation required to be transferred under section 14, statutory interest payable under section 11A and subsection 4A of section 3, or any charges payable by him under any other provision of his act or of any provision of the scheme or the insurance scheme may, if the amount is in area, be recovered in the manner specified in section 15B to 15G.
Hmm.
They are entitled to recover the principal amount along with that interest. Now
Statutory interest
is 15% statutory interest, my lord.
or any charges payable by him under any other provision of this act of any provision of the scheme or the insurance scheme.
Yes.
It includes everything.
It doesn't include.
Because at that time, how do you visualize that you will be able to pay when the notice is issued? When the demand notice is issued in 2019, suppose if you pay next day or within a reasonable period, then matter would have been there. Now it had gone ahead further and it had to be auction and then it has to be finally paid in the year 2022 or 21 or 22. Obviously, this accumulation of interest charges and has to be counted and otherwise they'll be deprived.
When a garden is sold, except your statutory dues.
And it's
Which
it's
I'll
not your
just give a
money.
reply.
It's
I-
not your money which
I'll
you
just
have
give-
given it for bonus.
No, I'll just, bonus
It's
they
a
cannot.
provident fund.
Provident fund, I'm not denying.
Their
I-
money.
I'm not, your lordship will please understand, I'm not denying their provident fund. They are entitled to,
No,
what I've
The
started by
problem
saying.
is the accumulated interest,
No.
charges, everything
No,
they have
I'm sorry, I'm
calculated.
sorry to say that. My lord,
If you are
I'm just-
disputing that,
I'm just
then-
giving reply.
Hmm.
My lord, the provident fund is only entitled to recover, which is a certificate which is given to a particular, the person concerned, where the amount is due.
See,
They cannot go beyond that notice, my lord.
this is 2028 is not a the certificate.
Which one?
It's a page 28 is not a it's not a certificate.
It's 100% is certificate.
No,
You
it's
see,
not.
Heading C,
Certificate under section 15.
see the heading, please see 28, certificate under section on the top. At page 28, certificate under section 15.
Yeah, you are hereby requested to recover the aforesaid
No, no,
dues.
please see.
This is a letter to the recovery officer.
Please, my lord, please lead the first on top.
Yes,
certificate under
then
section
read the
15.
final, last,
Yes, I
last
am reading.
bottom, please.
Yes. This is a certify that sum of rupees which is due from Balipara against the area PF cost 15% statutory interest on delayed deposit so and so on
Now
so
it
and so.
refers to so and so.
Yes,
You are hereby requested to recover the aforesaid dues accordingly under the provision of this act.
yes.
This is by a letter by the
So,
Board of Trustees.
They have recovered. They
No,
have
no,
recovered.
I'm saying it, it's not a certificate. It's a letter to recover.
No.
Then only the recovery officer will
But-
issue a certificate.
No, this is a certificate. I'm sorry to say it's a certificate.
This is not a
This is
certificate.
my understanding. That's your lordship.
No, this is a letter,
No, my-
this is a letter
But
to the recovery officer. At least see, sir.
no, this is, my lord, your lordship may form an opinion. This is my
It's
submission.
moving- It's not
No,
moving way.
that's my
By
lord,
itself, it's
your
so, sir.
lordship may reject my contention.
No, no,
that-
it's not.
No, but that's my submission. I am
I'm
putting
trying to
forward.
understand, sir. I have
that's
not
not-
decided yet, yes.
No, that's why I'm saying this is kindly see.
To me,
15B.
this is a letter for recovery
Please see
letter
15.
to the recovery officer. This is not a certificate, what I'm trying to say.
Please see 15B1. of
Yes.
the Statute. Who is entitled?
Yes.
Please see 15B of the statute.
Hmm,
Issue of certificate
hmm,
to the recovery officer.
yes.
Kindly see. 15, where any amount, 15B at page 241,
Hmm,
issue of certificate to recovery officer.
huh,
15B, where any amount is in area under section 15, the authorized officer may issue to the recovery officer a certificate. This is a certificate, my lord. Kindly see what is written below. The certificate under his signature specifying the amount of areas and recovery officer on receipt of such certificate shall proceed to recover the amount specified therein. How can they go beyond it, my lord? Specified therein. This is a notice at page 28. Therein from plantation or as the case may be, they employ by one or more of the mode mentioned herein below. So this is what they can certificate, my lord, which has been issued. Kindly see, my lord, at page 28 again. See the page 28 again, my lord. This is what 15B1 says. Issue of certificate.
Recovery officer.
This certificate has to be issued to the recovery officer. Has to be given. This is a certificate. Kindly see, my lord. See again page 28, my lord. Correlates with 15B1.
Yes, you are correct, but this is a certificate of recovery. This
Yes.
is not a certificate of the liability.
No.
Is that it?
Page 29.
29, kindly see, my lord.
After that, there's a demand notice to.
There is a, no, after that, there's a notice of demand at page 29. Kindly see notice of demand at page 29, my lord. Second page. Notice of demand.
Please take.
Please take a notice certificate dated 110, that is, this is page 28, 110 has been forwarded by the authorized officer so as well for the recovery of an amount. Kindly see, my
The
lord.
amount is the same.
Amount is the same. See 1/97, amount is the same.
It is issued to me.
So there is a separate certificate
Yes.
of
This is a
liability.
certificate which is issued, my lord, at page 28, and a notice is at page 29. Amount is that same amount, 1/97.
It's okay, I've understood. What
Yes.
I'm trying to understand is that this is a certificate to by the authorized officer
Correct, my lord, right.
to recover, to the recovery officer to recover
Yes,
the amount,
yes,
right?
correct.
Thereafter, there is no further, if the amount is recovered, a certificate is not required to be issued
No.
No,
by the recovery officer.
The satisfaction, enough, they have recovered, they have done, that duty is over, my lord.
Unlike the debt recovery.
Right, correct, my lord. That's my submission, my lord. They cannot retain. They can only go to the extent of the amount recovery certificate which they have issued. Why not? Not beyond that. You have recovered, fine, you have done it, we accept it.
But
But-
we'll pay the liability, other charges.
Other terms, new management has to pay. They cannot take it for new management whenever they had new
No,
management.
no,
it was
on the PF, on the PF,
PF they have recovered, but
Ah,
they are saying
recovered
about the other
because
charges.
section 15 says all other charges,
All other charges, whatever it is
including
mentioned,
the statutory interest.
that what is, they have sold this garden, it is now their liability to pay it. We are only concerned about our certificate which was issued by them. Otherwise, they could have mentioned everything in the certificate. Head-wise, column-wise, they could have mentioned it. Or issue a fresh certificate. That could have been done by them. They have not done. They have not done. They could have issued a fresh certificate. How can you do something which is not in the, they are trying to build up a case by filing an affidavit. This is what is required. Inadvertently, we have not mentioned it. Now we are mentioning it. Can you improve your case by not giving a notice to us also?
No, it's not that.
No, that is what they are trying.
Why-
They are trying to
What I
deter.
fail to understand is that suppose it's a recovery. Certificate to recovery was issued,
Yes.
and if it is recovered, then matter would have been in there. But it has proceeded further by auction, put on auction, and then out of that,
They,
Shall proceed.
I
it has
just,
to be
yes, I'll
paid.
just, recovery,
So by that time, it
I-
goes 2
skip-
years, 3 years,
I'll-
4 years.
no, suppose recovery, this recovery certificate was issued, notice was issued to us, this is the amount due.
Hmm.
If I could have paid, the matter would have been ended.
The
Now,
amount which they have
I'm
claimed,
just giving a
yes,
reply.
yes.
Matter would be ended. What they have done, if the matter is not ended, then there is a provision that you could not pay. So what we'll do it, we'll go ahead with an auction.
Ah,
So which they have done it. Because they have to sell it and they have to recover it.
ah.
Now they put it for auction. And the auction, when they have only to concentrate whatever the dues was there. So far as the earlier owner is concerned, only to that extent they can recover two heads. One is gratuity and one is PF dues under this certificate which they have issued. Now, now-
Section 15 says something else.
15 years doesn't, I
The
understand.
statutory or the interest as well as other charges.
Yes. What
Which
is
they have
other?
put in.
Other charges doesn't mean that you will go bonus and everything.
No,
You are
no,
not-
bonus, forget it.
No,
bonus.
you are not entitled.
Page 97, 98 will not go. 96 saves
Yes.
the interest and other thing. Bonus is on the next page.
But
Before bonus, it comes around 6
No.
crore.
they are entitled to recover only what is mentioned in the
That I
certificate.
have understood. That's
They-
why I'm saying.
Yes. But
As you said, had you paid it,
yes,
when the recovery was, say certificate, recovery before certificate was issued. But it has gone further, proceeded further,
what I am saying,
and was put to auction.
I am not entitled. Why?
Hmm.
Because why I am not entitled? Once I could not pay, the garden is under attachment
Hmm.
and it is given
Ah.
to a party.
Hmm.
It is under attachment.
Hmm.
So now he earns out of it. Now at one, there are a lot of gardens. There are about 15 gardens of Assam Tea Corporation Limited. 15 gardens in the state. Now they decided to lease out and they have leased out. But there are gardens which they have sold also. Now, till that period, which my lord, a period is there. Now, when you put it, given a particular Jimmanama, it is his duty.
Is it provided here?
It is his duty. No, see the attachment. One is, it is attached and the purpose kindly see. It has been,
Attachment and sale of the.
no, I'll just put it this way, my lord. The attachment of this garden, once we could not pay, is on 28/11/2019. 28/11/2019. At page 32, my lord. At page 32 is the attachment. Lordship got it? Page 32. At page 32. What was the provision? No, no, yeah, the provision কি আছে? Attachment দিলে কি করে কি নকৰে 32. 32, Lordship got it, my lord. After payment, we could not make the payment as per recovery certificate. Then at page 32 is the attachment. This is what is the provision? If you see at 15, my lord, 15 B, my lord. 15 B. See the statute 15B, which we read, 15B1, and say the proviso, my lord. Proviso provided, Lordship got it? On the top, provided that the attachment and sale of any property under this section shall first be effected against the properties of the plantation, and where such attachment and sale is insufficient for recovery of the whole of the amount of areas specified in the certificate, the recovery officer may take such proceeding in the property of the employer for recovery of the whole or any part of such areas. The authorized officer shall issue a certificate under subsection 1, notwithstanding that proceeding for recovery of areas by any other mode have been taken.
That is. Okay, yes. That's all.
Yes. Well, two things I just want to show. 15D. 15D. See 15D. 15D2.
You can correct the certificate if you want.
15D2. Notwithstanding the issue of certificate to a recovery officer under sections 15B of the authorized officer shall have power to withdraw the certificate or correct any clerical or authentical mistake in the certificate as may appear to him.
So you can correct it.
So that what they could have done it under the provision of 15D2, which they have not resorted.
And 15F.
And see 15F now. 15F, my lord.
You can use any of these following modes for recovery.
Other modes of recovery, see 15F. Notwithstanding the issue of certificate to recovery officer under section 15B, secretary cum provident fund or any other officer authorized by the board may recover the amount by any one or more of the following modes. So these are the any modes he can recover.
He chose sale.
Hmm?
He chose sale.
So what he decided to sell this garden by auction.
Once it is recovered by selling the vessel on auction,
Yes.
these other modes of recovery will not come into play.
No, once they, that's why these are other modes of recovery. Once they have decided to sell, then it's gone.
Now, what I'm trying to ask, I mean, this thing is that at the time of payment, when there's a interest and other charges, if it is accumulated, what is the mode? What is the procedure prescribed? Is there anything? Yeah.
Statute, I have, this I didn't find.
Am I asking if
No,
there's,
that's right.
if,
Yes,
I just wanted to know
yes.
if there's anything.
There is,
If there's
this-
nothing, nothing.
Yes.
Yes.
So same procedure shall have to be followed, my lord.
What, sir?
By issuing a recovery certificate, my lord, for realizing the other, the outstanding dues, my lord,
Yes.
the balance dues, my lord.
So what is your thing?
Yes, I will satisfy your lordship, my lord. Well, first of all, my lord, I'll take your lordship to our additional affidavit, my lord. Take on.
Yeah, for all the respondents, sir.
Right.
All the respondents. The Assam Commissioner,
Respond number 2, 3, 4, and 5, my lord.
okay. Yes. So first challenge goes, it has been withdrawn. Public auction, I mean, the notice to the public, it's gone, it's already withdrawn.
There's nothing to be.
And now matter is very simple.
Matter of
According-
action, then when did they have the petitioner is my lord disputing about the amount, my lord, the amount which you have adjusted, my lord. So that at best they may be directed to approach the authority concerned, my lord,
but sir,
with the proper representation,
No,
my lord.
what they're saying is that you have issued a certificate mentioning certain amount with the interest and other thing. Once that is recovered, rest of the balance amount has to be refunded. Because there's no, under the provision of this act, there's no provision that you can, I mean, pay.
Not this, the amount you have, the recovery of the amount by, we have received, my lord, by selling the garden, my lord, that is not sufficient to recover the entire
No,
liabilities, my
but
lord.
then what they're saying is under the act, whatever is mentioned in the certificate, the amount which is mentioned in the certificate, including the interest and other thing, charges, it is the only payable, I mean, recoverable from the auction. Rest of the amount has to be refunded.
My lord, the amount to be refunded to the petitioner, my lord. But this, the amount which we have realized by selling the garden, that was not sufficient, my lord.
That's what I'm saying.
So that was not
No,
sufficient.
no, certificate, you have issued a certificate for 1 crore 97 and odd rupees.
Right.
You have sold it for 5 crore and odd, right? Now, what they are saying is, under the act, it is the only amount which is in the issue mentioned in the certificate
Right.
that you could have recovered from him. Rest amount has to be refunded.
Now, by filing the affidavit, my lord, to our additional affidavit, my lord, he has admitted. That was not actually, therefore, prior to that, I am drawing your lordship attention to page 96, my lord.
And 96 we have seen. Yes,
What the amount you have mentioned, my lord,
yes.
that is the sale proceeds of 5,97,000.
That is what they are saying is that you could not have done it under the act because act doesn't provide, I mean, authorize you. You have to only recover the amount which is mentioned in the certificate. There's 1 crore 97 something odd rupees. Now you have, I mean, recovered around this on entire amount of 5 crores, which you could not have done under the act. That is what their submission, their case is.
No, but actually, my lord, this is the statutory liabilities, my lord.
That's what I'm saying.
So just
How,
statutory
how
liability-
under the act,
No,
how you could
kindly,
recover?
kindly, I am drawing your lordship by page 96, my lord,
Yes.
what we have mentioned.
This mentioning, they are not agreeing. You could not have done under the law. That is what they are saying. I have seen it.
But by filing their reply to our additional affidavit, they have admitted, my lord, that they have included, admitted about their, my lord, this, the gratuity amount also, that was, which was not mentioned in the recovery certificate, my lord. Now they have admitted by filing their additional affidavit to our, to that, huh? To our affidavit, my lord.
Sir,
Page 119, my lord. Page 119, my lord, kindly. What they have said, my lord. 119, my lord.
119.
Facing my lord, amount claimed under recovery certificate dated so and so, 1,97,47,669.
Hmm.
Amount payable as gratuity as per respondent statement at page 96 of the additional affidavit, 1,63 lakhs and 82,000. That
Hmm.
now they have admitted, my lord.
When did they have
They have
admitted?
admitted,
When they have admitted?
my lord.
Why we have
Then
admitted,
next,
my
my
lord?
lord, next amount received are through public auction sale held so and so,
Sir, where you are reading?
my lord.
Which
Page
para?
119, my lord.
Yes. 119, which paragraph?
Paragraph 6, my lord.
Yes.
These are the breakup they have shown, my lord.
Hmm.
Amount claimed under recovery certificate, 1,97 lakhs 47,000 so and so.
Yes.
Amount payable as gratuity.
Yes.
This amount was not included in the recovery certificate. my
Doesn't
lord.
matter. It's
Now they
okay.
have admitted, my lord. Now
Yes.
they have admitted, my lord. Then total it comes to rupees 3 crore 61 lakhs 29,708, my lord.
Yes.
Amount received through public auction, 5,97,000, 5 crores 97 lakhs so and
Yes.
so.
Yes.
Then amount refundable. Now they are demanding this amount, my lord.
Yes, obviously. That's
No.
true. That's what I said. They are
No.
saying. Gratuity, you can record.
What about this amount, my lord? That there's no. Page 96, my lord.
Hmm.
Again, I am pressing before my lordship, my lord. This additional, this amount, my lord, B, my lord, B, clause B, my lord. Additional area PF contribution for period is so and so, not added to the aforesaid recovery certificate due to in this amount was not mentioned, my lord.
You may be correct,
My
but
lord.
what they are saying that you could not have recovered this amount unless you issue the fresh certificate, right?
My-
Rather, they're saying that even if they admit this 163 gratuity amount which you have not mentioned, they are saying that this is they are entitled. It may not be mentioned.
Clause 6, C, my lord, 15% statutory interest due to delay in deposit of the PF dues, my lord. This it comes to rupees 3 crores or 5 lakhs and 93,000, my lord. This amount, why we can adjust, my lord.
Under this provision, how you recover
No,
that?
before that, for that I will have to place before lordship, my lord, this to my additional affidavit, my lord. Page 110, my lord.
Hmm.
How they have avoided, my lord. In furnishing this about their liabilities, my lord.
110.
110, my lord. 110.
110.
Paragraph 2, my lord. What they have omitted to apply the authority concerned about their liabilities, about the statutory, even statutory liabilities, they have not mentioned. That they were asked to apply the authority concerned, my lord. That the honorable, may I read, my lord?
Hmm.
That the honorable High Court of High Order dated 22/4/2025 made a specific query as to whether the PF authorities have any sanction and authority under the law to adjust on its own the other dues, including statutory dues like gratuity, bonus, etc., out of the state sale proceeds of the tea estate belonging to the petitioner, when the respondent organization is empowered only to take action for recovery against the provident fund, pension fund, and the deposit linked insurance fund dues only. Further, the honorable court raised another query as to whether beyond the recovery of the amount mentioned in the certificate, the PF authorities can recover any other dues without issuing a fresh notice thereof on the ground that inadvertently additional area PF contribution for the period 10/9/2019 to 28/3/2020 amounting to 17 lakhs 79,728 was not included in the recovery certificate. Over and above, an amount of rupees 3 crores 5 lakhs 93,526.51 towards 15% interest for delay in depositing the PF contribution. Then gratuity, past liabilities amounting to rupees so and so for the year 2018 and 19, rupees 16,15,645 towards monthly gratuity contribution payable from so and so, so and so, so and so. In total, it comes to rupees 6 crores 9 lakhs 83,517 for 14 paisa, inclusive of recovery certificate amount of rupees 1 crore 97 lakh 47,669.10 paisa, which is not sufficient to meet up out of the sale proceeds of rupees 5 crores 97 lakhs. Over and above, there were other statutory dues such as bonus at the rate of 20% against the wages paid during the period so and so, gratuity due payable to the retired workers and staff. According to the instant additional affidavit has been filed by the respondent number in reply to the query made by the Honorable Court in support of the said stand taken by the PF authority so as to assist the Honorable Court for proper execution of the matter involved.
Just wait.
My lord.
You just reiterate what you have done at page 96, right? You have not explained what the courts wanted once. You have not explained.
Next paragraph.
Yes.
There are three now, that is.
Huh.
That with regard to the first query, the different date to state. The recovery proceeding under section 15 of the Assam Tea Plantation Provident Fund and Pension Fund Scheme Act 1955 as amended up to date has laid down the recovery procedure for recovery of area provision fund and DLI dues. However, before setting the sale up, settling the sale proclamation, a notice being CP number 17, namely notice for settling a sale proclamation is required to be served upon the defaulter, asking him to bring to the notice of the recovery officer regarding any encumbrances, charges, claims, or liabilities of the due estate attached. In the present case, the aforesaid CP 17, namely notice for settling of sale proclamation, was duly served upon the petitioner, asking them to declare any encumbrances, charges, claims, or liabilities attaching to the tea estate. But the petitioner deliberately and willfully failed to declare the encumbrances, charges, claims, or liabilities in respect of their tea estate under attachment, despite of the fact they were fully aware of all their statutory and other liabilities. The PF authorities do not adjust any other dues other than the statutory dues recoverable from the defaulter tea estate. However, the other dues pertaining to the liabilities of the defaulter are adjusted only after receipt of such claims from the respective claimants. It may be pertinent to mention here that only the statutory dues are admitted and are duly verified from the respective authorities having jurisdiction over such matters. In this case, the area dues other than the PF dues adjusted are all pending dues pertaining to the liabilities of the petitioner. Copy of the notice that I have annexed, my lord. Annexer 1, my lord. This is annexer, my lord. Annexer, page 115, my lord. They were giving ample opportunity, my lord. Before selling of the tea estate, my lord, in a public auction, my lord, they have not come forward, my lord, for furnishing their particulars about their liabilities, my lord. Intentionally, they have avoided. This was the interest, that was statutory interest, my lord. 15%. They are the chronic defaulter, my lord. They have not only defaulted in depositing their own provident fund contribution, my lord, they have also defaulted in depositing their provident fund already collected from their employees, my lord, which is a very serious matter, my lord. My lord, the court has no but to settle the account, my lord. When they are disputing about the amount, my lord, they let them approach the authority concerned, my lord, by filing a proper representation, my lord. The authority will definitely consider, my lord, looking to the other materials on record, my lord, to settle the account, my lord. Let them approach. The direction may be issued to the petitioner company, my lord.
So according to you,
Well.
although this act in detail doesn't provide how the procedure to recover the accumulated interest and charges, but the in terms of the provident fund, this has been taken. For that, you have issued a notice for settling, which they have not
They have not
come forward.
They have not come.
Still then,
Yeah.
you are ready to consider your case if they come forward to settle their accounts.
That can be sorted out by the authority concerned of the PF authorities, my lord.
But they have you seen that your learned senior friend has vehemently, strenuously asked that you could not have done beyond the amount which is mentioned in the certificate under the act.
Hey, we don't now, they have repeated about this money,
No, that is.
yeah, gratuity amount, they have admitted, my lord.
They are gracious,
Although it was not included in that.
they are gracious enough,
My lord.
but you could not show, I mean, as of now, except to say that these are also under the statutory, I mean, the entitlement. But then under this act, how you have, I mean, followed this act by, I mean, recovering more than what is mentioned in the certificate.
Nothing.
Am I clear? Am I clear?
I'm sorry, my lord.
Not clear. Except to say that as per the Provident Fund Act, the provisions, you are entitled to, they recover all the charges, interest, whatever, gratuity, whatever, which comes to around 6 crore and all. You could not establish under this act that you can recover more than what is provided in the, more than the amount provided in the, I mean, the certificate. Under the act, under this act, there's no act, there's no provision. So, if there is no provision to recover,
No,
okay,
for
how
audit
can you
of this,
recover?
same
How
person-
can you
same person-
recover
same person
more?
shall appeal
How
for-
can you recover more than what is prescribed, given in the certificate?
Recovery certificate, other dues are still there, my lord. Then for the same procedure we have to.
What is the other statutory, I mean, provisions
This other,
where
that
this can be recovered?
page, that is mentioned at page 97, my lord.
Hmm.
Page 97 of our affidavit,
97.
my lord. ACM, then the staff dues claims, but that specifically that has been mentioned, my lord, specifically, my lord.
No, if these are the, I mean, the dues to be recovered, then what is saying that alternatively that there is a provision to issue a fresh certificate.
Not by them, by any other authorities. Their gratuity now they have been included, that's why I have considered. Now under the act, they have given that power. But not so far as the other dues are concerned.
Anyway, why don't you go and settle with them? They are ready to
They
consider
have
your
already
case.
decided, and they have, page 96, they said already we have decided. They decided. They decided.
We'll say, in that case, we'll say that as per there is no clear provision to recover the, I mean,
You say, there's a fine.
orders, I mean, the amount more than the mentioned in the certificate, you approach the authority and settle.
Settle means they, whatever is not under, provided under statute, they have to,
No.
yes.
This could be up to the authority concerned, but they authority definitely consider the.
Not up to, but so you are not able to show, sir, that you have a authority to recover under the act statute. How can we allow you to recover it?
No, this is the my statutory dues, my lord.
It's a lordship.
Just wait.
Yes.
Huh, yes, sir.
Statutory dues, my lord.
Yes.
That can be, that can. Authority concerned.
If it is a statutory dues, why this provisions is not mentioned? I mean, this act has not mentioned anything.
Mention by 15, my lord.
Yeah.
15B, my lord, 15B.
No, no, not 15B. It's 15 only. 15. छुट्टी
C1, my lord. Where any amount is in area under the section 15, the authorized officer may issue to the recovery officer a certificate under his signature specifying the amount of arrears, and the recovery officer on receipt of such certificate shall proceed to recover the amount specified therein from the plantation, or as the case may be, the employer by one or more of the modes mentioned herein below. There's a modes are mentioned, my lord, by attachment of the guardian, their arrest of the employee and his detention, appointing a receiver to manage the management of the movable. Then, my lord.
What is the Principal Act?
My lord.
You have the Principal Act.
Yes, sir. Assam Tea Plantation Provident Fund and Pension Fund and Insurance Fund Scheme Act 1955.
This is amended.
Amended, my lord. That's actually only section 15 that was amended, my lord.
This is what they done amendment.
To be honest, this is new subject for me. No, I have not come across this act.
Section 15, my lord, of the Principal Act, my lord.
Fifteen to amend kori mode of in ABCD.
15 has been amended and they brought that mode, A, B, C, D. You see 15.
See, there's another subject to what you say.
Yes.
This amendment only were on the recovery, procedure of recovery, right?
Yes.
The mode of payment and the entitlement as indicated in section 5. The other interest on a cursory glance
Yeah.
of the Principal Act, I think there's something more. So I'll determine. I'll keep it. We'll return after the judgment. Anything else? Nothing. Any judgment?
This is judgment.
No. It's very simple matter,
Yes,
but I would like to go into more.
yes.
Because
He-
your simple case
No, no,
is,
but-
if I correctly understood, first challenge to its goals.
Yes.
They have withdrawn, refund. You could not have recovered more than what is provided in the certificate.
Yes.
If at all, if there is any further recovery has to be made, either you should issue, you should
fresh-
follow the procedure by
Yes.
issuing a fresh
Oh, yes.
certificate, whatever. That's all.
Yes.
Otherwise, you could not have done.
You
So
could not
these
have
are
done.
the
Yes.
amount.
Because
I
that's
am
what-
entitled, you are entitled to recover from
Yeah.
me. The 3 crore something,
Yes,
rest you have to
refund back.
refund back.
And it is not provided under the amended act, it has not been provided. The mode has been provided in what manner recovery has to be made. Yes, sir.
So now,
And the specified amount
ah,
under the, act. That's what my case.
now I'll just would like to go into.
Please, and it is
this-
something to give an answer.
No, it's okay.
Yes,
I'll go into what I have understood in
yes,
this,
yes.
in this principal
yes.
act. We'll go.
Yes.
And maybe if there's no way out, you will give you a liberty to approach the authority. If in case, if there's no way out. All right. Let's see,
Cannot be-
let's see, let's see.
Your lordship is saying that we can't then this, but I find that's the best.
So if I cannot find way out,
I'm deeply obliged.
But
I'm
because
deeply
I-
obliged.
no, my learned friend is disputing about the, my lord, about the amount of which you have
yes, yes,
accepted, my lord.
then I'll also take care.
My lord.
Heard Mr.
Obliged.
Idas, then senior counsel assisted by
K. Taluk-
Mr. A.
K. Talukdar.
K. Talukdar, learned counsel for the petitioners. Petitioner only,
Yes.
petitioner. And also heard Mr. N.C. Das, learned senior counsel assisted by for respond number 2, 3, 4, and 5. And Mr. S.K. Sharma for 6 to 9. Who are you?
Auction procedure, my lord.
Nothing to. Who is for the state? A. Chetia, learned state council for respond number 1. Hearing concluded. Judgment to follow.
50.
Obliged.
Judgment in order to follow.
I think.
What is that act, name of that act? Yeah, fund.
And Vincent has. Vincent.
Amendment Act. 2016.
Item. 3.
My lord, we were directed to file an additional affidavit. We need some time to file.
Why you have not filed? It's 15/12/2025. Yes? Incorrect annexures
I have pointed out, my lord.
on the prayer of Miss MS
L Thakur,
L. Dow,
L Thakur.
L. Thakur, learned counsel for your name is there,
appear-
appearing on behalf of Mr. A.K. Das,
Yes,
learned counsel for the petitioner. Further, 2 weeks time is granted to file amended, also additional affidavit,
additional affidavit.
additional affidavit.
Yes, lordship.
Additional affidavit as permitted by this court on 15/12/2025.
Right.
I'm appearing for respondent to
You-
entry, is thus.
H does for respondent, all the respondent. Respondent number 2 and 3 is present, huh?
Item 4.
Copy has been served. আমি কালকে আসবো সাথে। কোনটো আমার হবে কোনটো
আমি very confused, respondent number 10. Respondent number 11. 11 is okay.
My lord, there is an order passed by this court.
Hmm.
I am appearing for respondent number 11. So there is an order which has been passed on 15/12/2025.
Hmm.
And respective affidavits has been filed,
Hmm.
but we have not received
Huh.
the copies. Some
So-
of the copies we have not. So for a petitioner, there is no problem. But for
We
the
shall-
other side are concerned, we have not received. So at least they should serve the copies so that we know our the case.
Already order was there, why
Let them
you
serve
are
the
not
copies.
exchanging?
Let them serve the copies to us. দি দিবি দাদা। আর কোনটা আছে দিব? No, we have not got the copies also. I mean, Adhan, not here, na, tomorrow, problem. Nahi. I think they also said that we have not served. Let them serve the copies to us. ONC also has not served. Our copy is for.
And Mr. Sensor.
I am appearing for respondent number 10.
Have you filed the affidavit?
Yes, we have already filed affidavit, the matter relating to election laws. To last election was held in 2019. Thereafter, it is provided that every 2 years.
That's already recorded.
It's
But
recorded.
Lordship, my learned friend, respondent number 11 is holding since 2019.
No, whatever, I have to receive a copy. What do you say that? Let me, let them serve the copy. I'll give a reply to it.
It's already recorded.
Yes, already
It
recorded.
is recorded.
How
Lordship.
can,
We'll give
without giving a
you
copy, how?
another 1 week time to exchange the affidavits. I mean, the papers.
Yes.
It's already recorded since this case pertains holding of election wherein urgency is there and endeavors would be made for this expeditious disposal of the writ
Then
petition.
it, so
Already
may be
mentioned.
directing all the respondents to supply.
We'll
copies.
say, although affidavits have been filed by the parties, respondents, comma, Mr. D. Daslan, Senior Counsel, appearing for respondent number 11, submits that he has not been furnished with the copies
Yes.
of some of the
If you respond, yes.
copies furnished with the some of the copies of the affidavits filed by the respondents. In view of above, let this matter be listed after 1 week. In the meantime, the parties may exchange their affidavits. Okay.
There is the interim order, my lord, kindly be continued. Interim order kindly be continued,
For what?
for not to hold election, my lord.
Sure.
There is a-
Are you interested not to hold?
My lord,
I was not interested for election.
no, we are interested, my lord.
Then
But my lord, separate election should be held. My petition that is for that, my
why
lord.
separate election?
No, my lord, there is,
That's the case.
yes, my lord, there is,
That
yes,
say, why separate election?
we are newly, my lord, registered, my lord. When
Doesn't matter. There
No,
will
but
be
there is-
composite, what is to be done? No? The process is what?
There are three assets.
Huh.
Three assets.
Assam assets?
Some assets, Donut asset and Silchar asset.
Ah.
Normally, the procedure is that combined election is held on these three assets. Now, my learned friend has come to court here saying that separate elections should be held.
But
So far,
rather,
a different
what
assets
they
are
are saying that earlier it used to be a separate election.
No,
Then
no. We are,
Today also.
in 2016, there is a separate notification, my lord. We are, my lord, newly registered, my lord, association on, my lord, 2016, my lord, after.
under what authority you are saying, claiming that it should be separate election?
Yes,
No, Lordship, in 2016, Lordship, Jorhat asset was newly created, Lordship.
Doesn't matter.
Earlier,
They are not taking away your right.
Lordship, in other region.
They want to have a
election should
common
be in
election,
asset-wise.
huh?
Election was conducted in asset wise.
It's okay. Now they want to for common election.
What common.
So
So my content is only given is that our election should be on separate asset wise basis.
under what authority? I mean, under what law? Under what provision you want to have a separate election? Huh.
The India constitutions are.
I have seen it. That's why I'm just asking. I think, sir, nothing. Anyway,
no, my,
after a week,
yes,
interim order pass, let's continue. After a week for dismissal.
yes, there, after hearing, my lord,
Yes, obviously, that's why I'm fixing.
obliged.
I can find.
My lords,
Yes, sir.
this matter can be taken after some time.
Why?
My lords, this was part heard, my lord, Mr. K. N. Chaudhary, senior counsel is leading this case. My lord is on legs at court number 7, my lord, after some time.
This is what?
That land acquisition matter.
Okay.
Their contention that we have accepted the compensation.
On the last occasion, my lord said.
Urgency is there. Urgency is there. very small issue, a very small issue. In fact, he has already completed.
My lord. Supposed to rely upon some judgment and then we have to reply.
Then next week. Urgency is there.
Only thing, your lordship, the reference case is pending, though there is no
That's why I'm
stay.
saying, why not, we'll keep it pending, we'll keep it part heard.
My lord. Your lordship, can it be taken up on 28th?
28, we have fixed so many matters. We have fixed so many matters. And there are four days to working days. Make it 30,
My lord.
hearing day.
Well,
That will be better. Huh? Huh? Okay, 29.
great. my lord.
And Mr. AK Sahiwala,
Sahiwala.
counsel for the petition, and Mr. Deep Chanapati, learned counsel for the respondents. Although this matter is fixed for fixed for hearing today, it is submitted that Mr. Ken Chaudhary is engaged in some other court. Mr. As agreed to by learned counsel for the petitioner. Let this matter be listed on 29/01/2025 at 6 as for heard.
Great.
In this matter, we file our affidavit which is not on record, lordship.
My lords, I appear for the respondent number 3 in this matter.
What is the matter?
Matter, Lord, commercial complex, my lord, in a area allotted for child development, my lord. So I will file my reply, my lord.
Who are you?
I'm the petitioner.
Landowner.
No,
Are you a-
commercial place, side by that property, my lord.
What's the problem? Said by, it's not,
Business were affected, my lord. On that complaint, my lord, inquiry has been conducted, my lord. And on that inquiry, my lord, direction was issued to dismantle the construction, but that was not followed. That's why we are.
so you want that this court has to execute the order of the
No,
deputy
my lord,
commissioner?
therefore we approach before this honorable court.
Hmm.
And this honorable court take up the matter, my lord. And today I also have some difficulties because, my lord, the conducting council.
Today I have no difficulty. There's no case.
No, my lord, kindly, I will file my reply, my lord, because he said, on next week, my lord, may fix this matter, my lord. Because brief is not with me, my lord, the conducting council is ill and he is, my lord, because of the, I'm not in a position to properly, my lord, submit, my lord. If on next Friday, my lord, may fix, my lord.
You are for private respondent?
Yes, my lord.
Yes, madam, what to do? You are for?
Both of them, I don't know why they're making a party, actually got a small NGO on top of their.
Yes.
property. That's what I can actually be exempted from the case because we have got.
No, we'll hear them and we'll dismiss the writ petition and will impose a cost to be paid on you.
Oh, my lord, I'll file my reply, my lord. My lord, next week, your lordship may fix it, because today I also handicapped, my lord, because the brief is not with me, my lord.
As agreed to by learned counsel to the parties, let this matter be listed. Now we'll say, heard Mr.
M.A.I. Hussain.
Learned counsel for the petition, and you just said. Who is one?
9, 10, no?
Who is respondent number 1?
Yes.
And Das.
And vote 2, 3.
Who is 1?
Panchayat department, lordship. Panchayat.
For 2 and 3, huh? And Das and MS R Chaudhary for respondent. 8 and 9. 8
9 and 10, lordship.
and Mr. S Day for respondent number 9 and 10. As agreed to by learned counsel for the parties, let this matter be listed after 2 weeks.
Hello.
Is there any interim order? No.
There is an interim order, my lord.
Huh?
Interim order. Demolition No, interim order, sir. There's an interim order, my lord.
Where is the interim order?
My lord,
By which order?
the status quo has been directed, the first order, my lord, the first day, my lord. The motion is to submit an interim order.
No, no. Where is the status quo?
Uh,
It simply says that in the interim measure, as an interim, the additional deputy commissioner direct take stock of the present stage of
my lord,
construction.
that is the interim order.
That's all.
My lord, that is the interim.
That's all.
That is the
Will not say anything.
my lord. Oh, bless.
What about 27? Item 27. No, no. Item 27.
Item 27.
May I please, your lordship? But can it be?
May it please, my lords, I am appearing for the respond number 3 in this matter,
Hmm.
the resolution professional, my lords.
Where now we'll take it up to item 6. Now we are on item 27.
Oh, my apologies, my lords, my apologies.
Just
Sorry.
wait for your turn. Yes.
But can it be taken after some time?
What do you want today? What is this?
Item 27, Lordship, we have been directed to produce the records.
Yes.
This is regarding an election of the Panchayat, Lordship.
Then
Lordship, we have not received that record, Lordship. So Lordship may fix it. Any other?
heard, Mr.
H. Ahmed.
Learned Council. On the, Mr. H. Sharma, Learned Council, State Council submits that although he has been directed to place the record,
Earlier occasion also, my lord.
no records. He is yet to receive the record. Therefore, press for listing of the matter after 2 weeks. Praise allow.
Date
List
may
the
be fixed.
matter after 2 weeks.
Date may be fixed, my lord.
After 3 weeks, Lordship.
2 weeks.
Lordship.
Date may be fixed.
What is the urgency? Election
Election matter.
of what?
Of President of a Panchayat.
2025.
The private respondent, they have already filed their affidavit, but they have not yet responded. They have stated that they have lawfully elected.
Okay. They have filed the affidavit.
Yes.
You place the record, we'll see.
Much of this.
If they have elected not to, contest, what can we do? Yes.
Item 6.
May it Lordship.
Yes.
Discuss Lordship, I'm appearing for the petitioner and I'm led by Mr. Ken Chaudhary, Senior Advocate.
Huh.
He's on his legs in connection with the Pathan matter. May
This
I
is,
please-
this is listed for orders.
Orders, yes.
For what?
There is honorable court for disposal of the entire case.
Why?
Lordship, this IA I have filed, it is arising from the award passed by the Labor Court, and I have filed an IA under section 17B of the Industrial Dispute Act, because in the award, the Labor Court directed the management restatement and compensation, then to compensate me. But they have challenged the award.
No, today is listed for IA, consideration of the IA.
For hearing of the entire matter for
So
disposal.
it said in view of above, as agreed by London Council Party, let this matter be listed on 22. Supposed to appear on through video conference, however, due to technical glitch, he could not appear.
My lords, I am appearing for the respond number 3. On the last occasion, my lords, there was some issue that the link was not functional, so.
Yes. What do you say?
My lords, I have filed my reply to the writ petition. My
Hmm.
response is a linear response, my lords. I am appearing for the resolution professional. The company went into CIRP starting January 2024. My lords, there is an absolute moratorium in terms of the order passed by the NCLT, which my lords may find particularly on page 207 of my reply, my lords. And my lords, what they are in fact claiming, if they
Sir,
have, my
sir,
lord,
there is a difficulty today. The leading counsel, senior counsel who is supposed to appear, he's busy in some other court.
my lords.
Some other day.
My lords, very well, I understand. I am before my lords.
That the
And I request Mr. Kurdukar,
My lords,
if you can join physically, it would be better. This,
uh, I will take instructions to that effect, my lords.
you are from, appearing from where?
My lords, I am appearing from Mumbai.
Please do visit Guwahati.
My lords. I will take accordingly the instructions from my.
It's a nice place.
Indeed, my lords.
Yes. When do you want?
Any day.
Or Mr. So-and-so learn counsel for the petitioner and
I am for the workman lordship, respondent number 4. and
which
5.
one? One M. Chutia, State Council for Respondent and
I'm for respondent number 3, like.
Mr.
I am for respond number 3, my lords.
A. Kurdukar
My lords.
for respondent number 2 and Mr. F.Z. Majumdar for respondent 4 and 5. Come on, as agreed to by learned counsel for the parties, let this matter be listed after yeah, that's why. List after 2 weeks on fixing the date.
Long lordship, any date in the.
2 weeks, sir. It's the
3.
2023. Okay, we'll take care. We'll take care. On 20, you just choose a date. After 2 weeks. Today is what?
Today is
I think-
22nd.
22nd, my lords.
Lordship,
Lordship,
10th of February.
Ah,
10th of February.
9th or 10th, whatever.
10th is Tuesday on a hearing day.
Hearing date.
10th.
All right, lordship.
10th.
10th of February.
10th of February, my lords are keeping
Hearing
it on.
day,
10th.
10th. Hearing day,
Hearing day, Lordship, Tuesday.
10th,
Lordship.
10th, yes,
10th of February, my lords.
yes.
Lordship, may I submit a little prayer that no more adjournment shall be granted on that day, lordship, endeavor maybe make to dispose the matter, lordship.
Lordship, we are ready. today.
It's ready.
No.
That day also,
No,
all of you are
that-
ready
that-
because of the technical
That
glitch.
day also we are ready, Lordship.
That's why I
I-
requested your colleague, your learned friend,
My lords.
to appear physically.
My lords. My lords.
Lordship.
Highly obliged.
This flipping again and again.
Yeah, pleasure, Lordship.
Yes,
Await for serviceable, Lordship.
heard Mr. So-and-so learn counsel for the petitioner. Award service report.
Yes, Lordship.
Mr. So-and-so, so-and-so. Are you appearing for response?
No, I am not appearing for. 28. Am I Khan? No, sorry, my lord,
In this matter,
Huh?
I'm appearing for respondent number 12, 13 and 14, your lordship. Today I have filed affidavit in opposition.
So-and-so or respondent number 12, 13 and 14. And
Phone number 6, madam. I filed my.
respondent number 6 and then 11, then 5, then 10, then all are represented.
Yes,
All are represented.
I have also filed affidavit in
It's
opposition.
okay, all are represented. Which for state? Okay, 3. I think all are represented. 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. All. Are you sure?
I'm for a.
You just repeat. No, it's okay. Who else are appearing? There is the advocates had entered appearance on behalf 7, 11, 12, 13, 14.
12, 13, 14. 12, 13 and 14, I'm appearing.
12, 13 and 14, Mr. K. You just write. Then
I'm Smith for respond number 6, my lord.
6, then
I appear for 11.
11, then 5, then 10. So 5, 6, 3. Who is 1 and 2? You just record them. I was service report in respect of no, office note dated 21/11/20 reflects that respondent number 7, 11, 12, 13, and 14 are duly represented. And the ID card has been received in respect of respondent number 6. List of the service reports in respect of respondent 5, 8, 9, and 10 remains incomplete. List of however, today the learned councils entered appearance on behalf of respondents 5, 6, 10, 11, 12, 13, and 14. The list of service reports in respect of respondent number 8, 9, huh?
Lordship, 8 is the State Bank of India, Lordship. Respondent 5 also State Bank of India.
Then what about 9?
Karnataka.
5 and 8 is yes, who is representing 5? 5 and 8. Then what about 9? Then you just write 5 and 8, huh? Who is appearing? And then, now the only the service report in respect of respondent is awaited. List after 3 weeks. In the meantime, parties may exchange their affidavits.
Lordship, that may be fixed, Lordship.
Why?
Lordship, we have, my account is fixed, Lordship. All our
After 3 weeks? Somewhere 2016.
must. May I please, my lord? In this case, I am representing 1 and 3.
1 and 3.
1 and 3.
What about
Basically, my
4?
lord, this is a passport department. The respondent is a passport department.
What is 4? What about 4?
Perhaps, my lord. Respondent.
Officer in charge.
My lord.
In
It has to be represented by council representing government of Manipur. But I am not representing. I am representing Union of India, my lord.
Yes.
That is respondent number 1 and 2.
Yes. Then
My lord, they have given passport to this present petitioner
Hmm.
because of pendency of some criminal cases, my lord.
yes.
And there is a specific rule under the Passport Act that the department has the discretion if some criminal cases is pending against some individual, the department.
Are you for the petitioner?
I am not for petitioner. my
Have
lord.
you filed the affidavit?
My lord, today I just got the copy of it.
Okay.
I will be allowed to file my opinion opposition today itself, my lord.
None appears for the petitioner on call. List of Mr. B. Deb. B. Deka, Learned Council. CJC. Learned CJC enters appearance on behalf of respondent 1 and 2. Next para. Order dated. No, the Lauzima court order dated 21/01/26. reflects that the service in respect of restaurant number 3 and 4 have been duly effected. That's the services are complete. List after 4 weeks.
Deeply obliged, my lord.
Yes,
Service upon the respond number 2 is complete. As per office note dated
Complete.
21/1.
complete.
Yes.
And then you are list for admission, after 4 weeks earlier. Heard Mr. M.
My
M.
lord,
K.
there is
Moore.
one small error is also there.
Just wait. Heard Mr. R.K. Moore,
Arkemo.
learned counsel for the petitioner. Who is appearing? M.S. M. Burman, learned state counsel appeared for state response. As per office note dated 21/01/26, the service has been effected on respond number 2, list accordingly. The service is deemed to be completed. 6 and 7, you record, huh? Yes.
Yes, madam.
List
Right,
for
this
admission
requisition I
hearing
challenge
after
the order dated
4 weeks.
18/9/2025. What happened, my lord? In this case, earlier they have filed one, when the father of the respondent number 6 and 7 had executed one gift deed in favor of the petitioner, whereby land measuring,
No, today is listed for orders.
my lord. I
So
want
we'll
to,
hear you, we'll fix it for admission hearing, we'll hear you.
till then, the operation of the impugned order may be stayed.
What order?
Impugned judgment and order.
No, that cannot be like this. There's already an order.
Status quo order was passed, but that doesn't mean that the operation of the impugned judgment was of stayed.
You have been, liberty has also been given to parties to file appropriate application pending.
My lord,
In fact, your writ petition is not maintainable.
my lord, I have challenged the judgment and order of the ABR, Assam Board of Revenue, passed, whereby the gift deed executed by the father of the respondent was 6 and 7.
That is pending in the title suit.
My lord,
So you approach the
no, my lord,
court.
I am contesting that case. I have also filed one,
See,
my,
whatever interim
contract.
order you will consider your entire writ petition, but you try to, you whatever, if you are agree, if you think that you may be disposed or whatever, you approach the court,
my lord, accordingly I have
court.
approached.
and which has been already been provided. And interim order already considered status quo. Okay, list for admission after 4 weeks.
My date may be fixed.
Their last order, have you seen? There is a status quo order.
My lord,
And there is no bar to approach the civil court
my lord.
when the title suit is pending. I think that is the most appropriate way of dealing with the thing.
Date may be fixed, my lord.
Why?
Date may be fixed.
2025 matter after 4 weeks. See, we have given everything to you. Whatever possible, relief. That too in the interim stage. At the time of motion, moving the writ petition. Okay.
May it please your lordship. Lordship, I apologize. In the previous matter, item 29 supply, I was on legs and order.
Already passed, record his name. Already order has been passed.
Your lordship, it was time sensitive because in the month of March ending, the applications will close, and this was regarding that passport issuance of passport.
We said 3 weeks, ne? 3 weeks, make it 3 weeks.
And my presence may be marked.
Ah,
See go.
see go.
Obliged.
Who is Aram Chaudhary? Yes, what do we say?
Lordship,
Payment of ex gratia.
he is claiming rupees 5 lakhs,
5
my lord,
lakhs.
on the subsequent notifications
Hmm.
prior to happening of this killing incidents, my lord.
Huh.
So official stand is he is not entitled regarding as his
And
killing
hence,
incident yes occurred prior to issuance of those notifications, my lord. And accordingly, he has been paid 3 lakhs rupees. Initially, as per 92 rules, it was 1 lakhs. Thereafter, some enhancement comes into 2016, my lord, probably. Some court orders are also there regarding entitlement of additional ex gratia. That 92 act was repealed, my lord, notification, wherein it was stated that 1 lakhs plus providing service to the deceased, my lord, one of the next of case. It was repealed. Then in their place, enhancement of 2 lakhs, another 2 lakhs was comes, my lord, for enhance in lieu of that job. He has already in both the cases, they have received that 1 plus 2, that 3 lakhs rupees, my lord. And he is claiming that these notifications never stated anywhere that earlier should be deducted, those who get the payments from earlier. So he is now claiming that he is entitled for 5 lakhs, my lord. But as per government notifications, all the both the incidents occurred prior to issuance of those notifications. So he is entitlement up to only 3 lakhs, my lord, not for the 5 lakhs.
where is that government notification under which he is claiming?
Lordship,
You have not annexed.
my lord, in lordship will clear from second case, my lord, item 19.
Same incident.
Parties are different, but the stand and notifications are same, my lord.
Same incident.
2 different occasions, my lord. One is in 83, one is 89, and other is, my lord, killing incident
Yes, where page?
in lordship. Kindly see the affidavit of respondent number, my lord, 5 in WPC 6473/2021. That is item 19, my lord. There I have annexed all the notifications, my lord.
Filed by respondent number
5.
5.
In Firius Doimari. Petitioner's name is Firius Doimari. Paragraphs are 4, 5, 6, and 7, my lord. That covers both the cases.
Is 47. No. Well, dismiss for default. What do you say?
Other way also, I think on the basis of affidavit, instead of dismiss, my lord, his entitlement may be negated, my lord.
The
On
problem
account
is
of-
that he's
He is
not
not
there.
here, next. As lordship pleases.
Okay, non appears for the petitioner on call. Separate orders, huh? Miss MS M. Burman, Leonard,
For the state
State
respondent.
Council,
He is representing BTC authorities.
and Mr. R. Sharma for
BTC authorities.
BTC are present. The claim of the petitioner is for payment of enhanced ex gratia amount of rupees 5 lakhs
Hence dated
pursuant to notification dated
2014.
15/11/2014, 6/6/12.
14 in both the cases.
14 on account of the death of his mother, who reportedly was killed by the Boro extremist on 22/12/1993 at Udalguri Weekly Market. List of the petitioner being the next of kin of the next para, huh? Next of kin of the deceased has already been granted an ex gratia compensation of rupees in this case.
Both the cases, they have get the first 1 lakh, then enhancement
1
amount
lakh,
of 2 lakhs.
1 lakh,
Plus
thereafter
2 lakhs, another 2 lakhs.
another 2 lakhs for a total amount of rupees 3 lakhs under the
Which are not
existing,
denied by the reply
under
affidavit.
the existing, then existing.
Application existing during that period,
Then the notification oblique policy
existed on that period of time.
existed during the relevant period. This stuff,
In reply, they are not negated the
it's
same.
okay. Since the petitioner has already been paid an ex gratia amount of rupees 3 lakhs under the policy oblique notification invoked then, comma, preface, the petitioner would not be entitled for any further amount, particularly under the notification
As claimed for.
of the state, which was
Came in
framed,
force after the incident.
after the incident, subsequently, huh, Mr. However, it is this court. No, upon consideration, it appears that the petitioner has realized that he may not be entitled to any relief, and also, and therefore appears to be not interested to pursue this writ petition. Accordingly, writ petitions stand dismissed for non-prosecution. We'll say non-prosecution since he is absent. Non-prosecution, both the cases. Same.
Same.
Revenue. Correspond number 1.
For revenue department, it will be better because numbering are differently.
Okay.